Hello, I'm Kenny Leigh of Kenny Leigh and Associates. I'm with Nathan Kohley, our Director of South Florida. Today we're going to talk about relocation. Nathan, let's say a parent wants to move locations after an order has been entered for timesharing. Can they just move?
Well, it depends. If you are moving within 50 miles, in general, you can move. That could be met with some resistance from the other side as far as if your move resulted in a change of school district or something like that.
But that has nothing to do with the actual relocation statute, correct? That
Correct.
could be enough. That's okay. So if you said within 50 miles, do you measure it on the roads as they curve, or how do we do that?
No, it's as the crow flies. And so if somebody's wanting to move more than 50 miles, they must file with the court a petition that has to be verified by the person wanting to relocate. It must include why they are asking to relocate, why it would be in the child's best interest to relocate, as well as they have to include their parenting plan of what the timesharing would change to if they are going to relocate and take the child with them.
Okay, so they're filing a petition to relocate. You can't just move. The biggest thing that people need to take away from this video is how technical the things are in the statute. For example, it needs to be verified, doesn't it?
Absolutely. It has to be a sworn statement by the person wishing to relocate. If it's not, and the other side is trying to prevent the relocation or is simply trying to make it more difficult to relocate, you'll first be met with a motion to dismiss your petition, which will stop you from getting the hearing that you want to get the judge to allow you to relocate. It's important to remember that under no scenario can you just pick up and move more than 50 miles. If you were to do that without permission from the court or permission from the other side, you could run into serious problems with the court, as well as them ordering that you return the child back to where they were originally until the court can deal with it.
Well, what's also important to understand is if you are objecting to that relocation, there are technicalities that you have to follow there as well. That petition or the objection needs to be verified as well, correct?
Absolutely. So if the other parent is wanting to relocate, you will be served at some point with that petition to relocate that they will have filed. And you must object to that within the 20-day time frame in the statute. If you do not, then it's presumed that the relocation is agreed to by you, and the parenting plan that they would have included in their petition would be what becomes the effective parenting plan in your case.
Yeah, and again, specifics in the statute. If you just file something that says you don't want her or him to move, that's not good enough. You have to follow all of the steps in the statute. Now, of course, people can move if they agree, but I believe the statute says you need to do that in writing as well. If you agree, clearly there's things you can do, and if everybody's getting along, that's fine, but everything really needs to be by statute and be very specific. Now, also, something to remember is that usually in the statute, the court moves the hearings rather quickly. So the person who wants to move needs to be very specific, and the person who does not want the person to move needs to be very specific. If you want to ask more questions about this, what we have talked about are some generalities. If you want to ask more questions, feel free to call our office. Go to our website, divorcemenonly.com. Call our office and ask more questions, because there are so many more things that we can discuss concerning relocation. We have just touched the tip of the iceberg. We have offices throughout the state of Florida and Georgia. We're the largest family law firm in the state of Florida, and all we do is represent men. That's all we do all day long. Kenny Leigh Associates.